A very, very good evening to all of you, friends. A very, very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exam. Friends, in this session, I shall be discussing with you certain very, very important legal maxim. Now, this is part 4 of this very important series that we are running on our YouTube platform called Important Legal Terms and Maxim. Before I begin, those of you who haven't watched part 1, part 2, and part 3, I request all of you to watch those important sessions also along with this session, because listen, until you are aware of those important legal maxims that have been already discussed in part 1, part 2, as well as in part 3, it will be difficult for you to understand some of the maxims that we shall be discussing in the course of this session. So before I begin, this is part 4. It's a clarification. This is part 4. The previous parts are also very, very important for each and every one of you. I hope and I guess that most of you have already watched it. And if you haven't, then it is high time that in your free time, definitely watch these sessions, okay? Part 1, 2, and 3, okay? So a very, very good evening to all of you. A very, very good evening to all of you. Before I begin with today's session on important legal maxim, BYJU'S Exam Prep brings to you CLAT 2024 comprehensive course. Secure a seat at your dream NLU, wherein we are providing you with 300 plus recorded videos across 5 sections, 300 plus hours of live classes, 35 mock tests for CLAT and other law exam, along with video solution, a monthly e-magazine for current affairs, and the entire content is based on our extensive analysis of the last 5 years of CLAT question paper. So there are limited seats, and if you have any query, feel free to call us at 95388 95678. So that's it. Now, BYJU'S Exam Prep also brings to you a great opportunity to unlock your 3-day free trial access to all our courses. So go to the description box below and find the link whereby it will be possible for you to unlock a 3-day free trial access to our courses. Hurry up, do it now. It's free of cost. And if you do not like, later on, you don't have to pay anything. It's something free of cost. So avail this great opportunity, guys. Moving on. Some very, very important legal maxim. But before I start explaining you these legal maxim, first let me tell you what are legal maxim. Now, legal maxims are those words, phrases which are used by lawyers, which are used in courts to explain a principle of law. So there are certain phrases which explains a particular principle of law. That is what we understand by legal maxim. Now, most of these legal maxims happens to be Latin in nature. It is not in English, okay? So, it is important. Why? Insofar as your CLAT examination is concerned, you will get a particular passage. And if inside that particular passage, there are certain legal maxim or legal phrases, and if you do not understand those phrases, will it be possible for you to understand the passage in toto? The answer is no. So there might be some legal maxims or legal phrases inside those passages in your CLAT examination. तो वो अगर legal phrases आपके passages के अंदर आते हैं और आपको अगर ये सब phrases के बारे में पता ही नहीं है, then it will become difficult for you to understand the entire passage. And for this reason, we bring to you this session wherein we are explaining you some very, very important legal maxim. The first legal maxim: allegiance contra non est audidiums. It means, see, allegations, elegance means allegations which are contrary, you will not be given audience, you will not be heard, will not be heard. Now, it means if you are he who is not to be heard, who alleges contrary things. Now, during a particular, suppose you have to give an evidence in a court. Now, one day you say, suppose there is a murder trial. Suppose there is a murder trial. And you say that, I was there during the murder. One day you say that, it was very dark, I could not see Mr. A. I don't know who committed the murder. The next day you say, no, I saw Mr. A. The third day you say, I saw Mr. C committing the murder. So, he is not to be heard who is alleging things that are contrary to each other. If you are making contrary statement, if you are making contradictory statement, the court is not going to hear you. Am I clear? If you are making contradictory statement, if a person is making contradictory statement, then the court will not hear that individual. Am I clear? So, a person who is making contradictory statement is not to be heard by the court. Am I clear, all of you? Am I clear? Yeah, it is also called perjury. Very good, Pranjali. Yes, it amounts to perjury, and perjury is a crime again in law. Yeah, if you are giving a wrong statement, if you are stating something wrong in a court or a lie before a court, that amounts to perjury. Okay, perjury. Yeah, and that is itself a crime under the law. Yeah. Am I clear to all of you? Am I clear to each and every one of you? So guys, if you're liking this session, do press the like button. Yeah. Okay, let's move on. The next important legal maxim that I'm going to explain to you is called actuary incumbit onus probandi. It means it is upon the plaintiff to state and prove. So the burden of proof in a case, in a civil case, is on the plaintiff. So the man who goes to the court, so who is the plaintiff? Plaintiff happens to be that individual who goes to the court, an individual who goes to the court and says his right has been violated. Now, so plaintiff is that individual who goes to the court and says that his right is violated. So the man, suppose tomorrow I go to the court and I say my rights are violated, I have to prove before the court that my rights are violated. The burden of proof lies on the person who claims an incident has taken place. If tomorrow I say Mr. B has caused nuisance, I have to prove that Mr. B has caused nuisance upon me. Am I clear to each and every one? Am I clear, all of you? Did you all understand? Okay, brilliant. So here is a situation wherein we say that the burden of proof is on the person who alleges something. It is on the plaintiff, because the plaintiff goes to the court and alleges that his rights are violated, right? So I guess that you guys are understanding. Brilliant, 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 brilliant. Moving on. The next legal maxim. Felicis in uno felicis in omnibus. It means if you make one false statement, the entire thing becomes false. Now suppose you go to the court and suppose you have built your case, and one of the basic pillars on which your case is built up is false, then the entire case is false. False in one aspect means false in all respects. False in one thing means false in all. That is what the law is. Am I clear? False in one aspect is false in all respect. Now, suppose you have made a false statement. Suppose you have made a false statement in a case that you have filed in the court. The entire case falls apart. The entire case will fall apart, because if one thing you have said is false, then everything is deemed to be false at all. Am I clear? Very, very important, guys. Very, very important. This happens to be a very, very important maxim in civil law. Okay, in civil law. So if you have made a false statement in your case, or if you have made, or if you have said something false, then the court is not going to believe you for the rest of you in the case. Okay, तो अगर आप एक बार झूठ बोलते हैं और वो पकड़ा जाता है कोर्ट के सामने, तो जज साहब आपको एकदम ही नहीं सुनेगा, क्योंकि उनको लगेगा कि ये पूरा चीज ही फॉल्स है. Right? Okay, brilliant. Moving on to the next important legal maxim. Ignorantia facti exquisat. Ignorantia juris non exquisat. Ignorance of fact is excusable. Ignorance of law is not. So ignorance of fact, as we say in law, that ignorance of fact is an excuse. Ignorance of fact is an excuse, but ignorance of law is not an excuse in our legal system. Now, factually, if you make some mistake, okay, if you make some factual mistake, okay, ignorance of fact is an excuse, right? Now, but ignorance of law, suppose you say that I do not know a particular law and that's why I violated that law, it cannot be excused in a court of law. So, ignorance of law is not an excuse. Very, very important. Now, suppose you say that, I am not aware whether in India I can cut trees or not, but there exists a law that you cannot cut trees, suppose. And suppose Mr. A starts cutting trees. Can the police come and arrest him? Yes, of course, because ignorance of law is not an excuse in the eyes of law. Moving on to the next important legal maxim. Impotentia excusant legem. It means if an act is impossible in law, if an act becomes impossible in law, the court cannot force someone to do that act. Now, suppose impossibility is an excuse in law, okay? Now, suppose I had entered into a contract, Mr. A had entered into a contract with B. A is from India and B is from Pakistan, okay? A and B enters into a contract. A is from India, B is from Pakistan. A was supposed to deliver 100 metric tons of rice and B was to give 100 crore rupees. Now, they were to give all this. They entered into an agreement and A said that I'm going to give the rice in the month of August 2023. Now, suppose before August there is a war. between India and Pakistan in July 2023, and both the countries decide that we will not have any kind of trade amongst ourselves. Now, it is impossible for A to deliver rice to B, right? Because some situation like this has happened. So impossibility is an excuse in law. So B cannot sue A in and claim compensation because A failed to fulfill his promise. B cannot sue A for failing to do something which he had already promised to do under the contract, because impossibility, what is the impossibility? Because of the war. It is impossible during the war to transact. Yes, it is close to the doctrine. It is very, very similar to the doctrine of frustration of a contract under Section 56 of the Indian Contract Act. Okay, Section 56 of the Indian Contract Act. Okay, Section 56 of the Indian Contract Act of 1872. Am I clear? Frustration of a contract. Okay, frustration of a contract is what is there. Okay, am I clear, everyone? Is that clear? Okay, moving on to the next one. Lex non cogit ad impossibilia. Same thing. The law does not compel a person to do which he cannot possibly perform. Now, suppose there is something that is impossible. If there is something that is impossible, which a person cannot perform, can the law compel him to do something like that? The answer is no. The law is very, very clear over here. The law is very, very clear over here. The law simply says that if there is something that is impossible, that is not possible for a person to perform, can he be compelled by law to perform? The answer is no, he cannot be. The law cannot force a person to do something which he cannot possibly perform or do. Am I clear, everyone? Am I clear to everyone? Okay. Am I clear, everyone? Okay. Moving on to the next one. Nemo judex in causa sua. It means nobody can be a judge in his own cause. Simple. No man can be a judge in his own cause. Now, suppose Mr. A is accused of a crime, and Mr. A's father, Mr. K, is a judge. He is a judge of a court, and he also happens to be the father of A. Now, can Justice K or Judge K decide on Mr. A's case? Can Mr. K, the judge of the court, who happens to be the father of A, can he decide on the allegation against Mr. A? Please tell me. Can the judge decide on his son's case? The answer is no. That is the principle, that no man can be a judge in his own cause. No one ought to be a judge in his own case. Is that clear to everyone? Am I clear? Is that clear, every one of you? Okay. Is that clear? Very good. I hope you guys are all understanding, right? Guys are all understanding. These are those very, very important legal maxims that you must know. Per incurium. Per incurium means by mistake. Now, there can be a judgment of a court which does not follow the law. A judgment given by a court and the court has come to this conclusion based on some wrong principle of law. That is called per inquirium. A judgment that is incorrect, by mistake it has been given. Suppose a judge, while giving a judgment, did not see what the Supreme Court 5-judge bench had said on a particular issue, and the judge went on to say something different. That is called per inquirium judgment. Am I clear? That is called per inquirium judgment. Am I clear? That is called per inquirium judgment. Am I clear? Is that clear? Is that clear? Any doubt? Any doubt? Okay, fantastic. So per inquirium means a judgment of a court, something that is done by mistake, a judgment that has come from the court without considering prior judgment, without considering the law, a judgment of a court which is incorrect. Next one, quid pro quo. Quid pro quo means something for something. Okay, I will give you my phone provided you give me your laptop. Quid pro quo, something for something, some kind of a consideration. Quid pro quo simply means something for something. Something for something, it means consideration. If I am giving you something and in return you are also giving me something, that is called quid pro quo. And generally it is used in negative sense, in the way that, corruption cases and all, quid pro quo. Judges say that, there was a quid pro quo between the minister and others. Okay, quid pro quo. I will give you something, you give me something. Okay, it is used generally in a negative sense, but it simply means consideration or something for something. Am I clear? Simply means something for something. That is the exact definition. Yeah, returning a favor. Okay, Pranjali, yes. Yeah, it's kind of returning a favor. It is generally used in the negative sense, as I said, because yes. Is that clear? Okay, brilliant. Moving on. The next one is ratio decidendi. Now, when a judge is giving a judgment, when a judge is pronouncing a judgment, the judgment is based on certain reason. Now, the judge finally says A is the winner or B is the winner. But what was the reason for coming down to that conclusion? The reason behind the judgment is called ratio decidendi. The reason or the rationale behind the decision of a court is called ratio decidendi. Now, judgment, the reason is the bedrock of a judgment. Okay, when a judgment is pronounced, what is the reason for coming to the particular conclusion? The judge will definitely ask, what is the reason? The reason is called the ratio decidendi. The reason is called ratio decidendi. Am I clear to everyone? Okay. Ratio decidendi means the reason why a particular judgment has come to a particular conclusion. The judge will write the arguments for both the sides, the decision of the court, various judgments of the court on a particular issue, and finally would say, based on these reasons, I have come to a particular decision. So the reason behind coming to a particular decision is called ratio decidendi. Okay. So guys, if you're liking this session, do press the like button and share this session with your friends. Do share this session with your friends, guys. Okay. Moving on to the next one. Res ipsa liquitor. Things that speaks for itself. Things that speaks for itself. Res ipsa liquitor. I'll give you an example. Suppose Mr. A and Mr. B are neighbors. They are neighbors. Now, Mr. A is playing loud music music in the at 12 at 11 p.m. to 2 a.m. रात 11 बजे से सुबह 2 बजे तक इन्होंने लाउड म्यूजिक प्ले किया 100 डेसिबल. Now, this simply means that B has been disturbed. B can tomorrow go to the court and say, it's a case of nuisance. If the judge says, how? He was playing 100 decibel music between 11 p.m. and 2 a.m. The court will say, the fact that this action speaks for itself that you have committed a nuisance. The fact that somebody was playing loud music between 11 p.m. and 2 a.m. simply means that, yes, it is a case of nuisance. Am I clear? Is that clear? All of you? Okay. Okay. Moving on. The next one is called BYJU'S Abi Remedium. It's a principle in civil law or in law of tort which says that अगर आपके पास कोई अधिकार है और उस अधिकार का हनन होता है तो आपके पास इन लॉ कोई रेमेडी रहेगा. So where there is a right, there is a remedy. If someone violates your right, you can go to the court and ask for a remedy. अगर if your आपका अगर अधिकार का हनन होता है, now I have a right to peacefully sleep in my house. If somebody is doing nuisance like playing loud music in the middle of the night, I have a right to sleep in the night in my home. Somebody is disturbing me. Somebody is creating nuisance. I will go to the court and the court will grant me remedy like compensation. So where there is a wrong, there is a remedy for that wrong. Where there is a right, for a violation of a right, there is a remedy in law. Am I clear, everyone? Am I clear to each and every one of you? Okay? Is that clear? Is that clear? Okay, moving on. The next one, volunty non-fit injuria. So what do you mean by volunty non-fit injuria? Volunty non-fit injuria is a defense in law of tort. It is a defense in law of tort. Means if I have accepted some risk that is involved, I know the risk involved, and even after knowing the risk involved, I am participating in that risk process. Later on, if I suffer some injury, I cannot claim compensation. Example, I know very well that, if I enter the boxing ring, the opponent party might punch me and, something wrong can happen. Nobody forced me to enter into the boxing ring. Nobody. I voluntarily entered the boxing ring to play boxing. And the other party punched on my nose and I start bleeding from my nose. Can I claim compensation? The answer is no, I cannot, because to a consenting party, no injury is done. Did I know the risk involved in boxing? Did somebody force me to go into the ring? No, I did it voluntarily. So if I have voluntarily taken part in a particular game in which there is a risk involved, I was aware of the risk and I voluntarily participated in that risk process. Later on, if I suffer some injury, I cannot claim compensation under civil law. Am I clear to each and every one? Am I clear? Is that clear to all of you? By getting hit by the ball while watching football match in the stadium. Yeah, Pranjali. Absolutely correct. Okay. Fantastic. So I hope that you have understood these maxims that I have discussed in the course of today's session. Okay, brilliant. So guys, BYJU'S exam prep brings to you CLAT 2024 comprehensive course, wherein we are providing you with 300 plus recorded videos across 5 sections, 300 plus hours of live classes, 35 mock tests for CLAT and other exams along with video solution, monthly e-magazine for current affairs, and the entire content is based on our extensive analysis of the last 5 years of CLAT question paper. BYJU'S exam prep brings to you this great opportunity to unlock your 3-day free trial access to all our courses. Go to the link given in the description box below. Click over there and unlock your 3-day free trial access to our courses. So guys, before I end, do subscribe to our YouTube channel if you haven't. Do follow us on our Instagram. Do like our Facebook page. Do join our Telegram channel. And do not forget to download the BYJU'S exam prep app today itself if you haven't. So guys, with this, we come to the end of today's session. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Have a great evening. Have a great week ahead. And tomorrow, of course, is Eid. So celebration is all across. Bye-bye. Take care. Have a great week ahead. Bye-bye. Enjoy yourself. Bye-bye. Good night.